Okay.
Okay, we will call this meeting to order. It is now 11 o'clock. This is the hearing on the variation request application 2023-47. My name is Michael McHenry. I'm the hearing officer. I'll be conducting the hearing today. I'm required to evaluate your request pursuant to the rules of McHenry County. If I approve your petition today, you will then go to the county board. Mine is only a recommendation, not approval. But if I approve it, then you simply need a majority of the county board members in attendance at that hearing. If I were to disapprove it, then you would need a 3/4 vote. And we are making a record today. I would ask you to keep your voice up. If a question is asked to you that requires a yes or no answer, please don't shake your head, answer audibly, and we will get started. This is the application 2023-47. The applicant or applicants would be Jennifer M. Mangers-Deans and Nicholas K. Deans are the owners of record. The request would be a variation within the E1 Estate District to allow for a setback of 15 feet from the required 50 feet from the west lot line for a detached garage in the effective side yard. The subject property is slightly over 1 acre. It's located at the southeast corner of the intersection of Peregrine Trail and Manda Drive. Common street address is 11620 Manda Drive, Huntley, Illinois, Township of Coral. Tax ID or PIN would be 17344280001. The property on the current land use, as well as all adjacent land uses, would be single-family residential. And the current zoning and adjacent zoning for the property and all adjacent zoning would also be E1 Estate District. 2030 plan designates it as estate. The property is improved with a 2-story frame and brick residence, wood deck, asphalt driveway. Is it asphalt or concrete?
It's asphalt.
Okay. I thought I saw concrete somewhere.
The new one.
The new
is,
one's coming.
Yeah.
We've upgraded. There it is. The property also contains a new concrete driveway and a foundation for proposed garage. There are no wetlands, and there was a building violation, and that has now been addressed and taken care of, correct?
It will be under this approval.
Okay, it said the violation file was closed after building permit K 51117 was issued.
Correct, yes, so the violation file was closed because the building permit was issued. As soon as this is granted, if it is, and then they will be in compliance with that permit.
Okay. And I would ask anyone who's going to testify, which would be you two, and then also Kim, please stand and be sworn in. I don't know why you have to stand, but promise to tell the whole truth.
Yep.
Yeah. Please cooperate. Promise to tell the whole truth and nothing but the truth.
I do.
Which one of the two of you would like to indicate why we are here?
I will. We went through the permit process back in 2023, early 2023, for this property. When we came back with all the requirements, it was lengthy, and we realized that we needed to do more work. So we actually requested to postpone the permit until we got a contractor, so on and so forth. Within those communications, we asked if it was still okay to move forward with the concrete, and we were told yes, that was a Coral Township process. So we went through Coral Township. After that was done, we worked with our concrete company to use the plat of survey for creating the driveway, as well as the foundation for the building, which after there was an anonymous complaint made from a member of the neighborhood, the county came out and explained that while the concrete driveway was Coral Township, the fact that we incorporated the concrete foundation, that was when the permit needed to still be in place. So we came in that day to talk with them about that, and that's when we set up the permit for the foundation. The miscommunication came in because I said concrete and I thought concrete meant all, and the county just thought concrete was driveway. So that's where the miscommunication happened on that portion. So once we applied for the permit, we already knew at that point in time that we were gonna have an issue because we set it back 30 feet from what we thought was our property line, but was not. It was in fact just 30 feet from the road, which is not where our property line starts. So when they came out to do the assessment, they found that we were in violation of that 40 feet from the property line, which is a total of 50 feet from the road. And so here we are. We had already poured, so we're asking for the variation. Otherwise, we'll just have to add on additional 30 feet to the back of the plot that we currently have to push it back to that 50 feet.
And how long have you lived there?
7 years this winter.
And your well is in the northern portion of your property, correct?
Correct.
Yeah, it's on the front.
It's on the
And
front
septic
side,
is in the back,
yes.
and this is nowhere near your septic.
No.
This will
Nowhere
not
near.
interfere. Have you talked to your neighbors about what you're doing?
Yes, we have, we went around and talked to all of the neighbors that we knew were getting the certified letter in the mail. They've all signed off. They signed a little piece of paper that's saying, we know what's going on, we're totally in support of it, no issues from any of the neighbors.
Did you determine who kind of filed the complaint?
We think so, that someone that lives in the cul-de-sac, not on the same
Yes.
street as us, they live in the cul-de-sac of our subdivision.
Okay, would that be on Peregrine Trail?
Yeah.
No, it's Huron Drive.
No, it's Condor.
Oh, Condor, yes,
Condor.
Condor Lane, I apologize.
And Manda Drive, what happens as one continues south on that road? Is it
Kind of
a
does like.
cul-de-sac? or-
Manda does a circle,
Yeah.
but it's Manda, then turns into Huron, then turns into Peregrine, and it comes back around. And then there's the option to do the cul-de-sac, you turn to the right, and that's where Condor Lane is.
Okay, but the traffic on Manda is fairly minimal. is it
Yes,
not?
Yeah.
yeah,
And no one's really driving through there trying to go anyplace else
Nowhere
other
else.
than your subdivision.
correct.
And with your proposed garage, there won't be any problem with the line of sight. You're not going to impede any traffic traveling north.
No,
Are the rules for a residence different than for an accessory structure?
For the setback,
Yes.
yes, residents would be allowed to be 30 feet from right of way.
And their residence would be within, or would be slightly within that 30-foot distance, would it not?
Correct, I believe it's approximately 40 feet back from the right of way.
But if we applied that 50-foot setback, the house, or at least a portion of the house, would not be 50 feet from the end of the property boundary, correct?
Say that again?
And I should say it more clearly. Okay, the northwest corner of the house is within 50 feet of the property line, is it not?
Correct.
And is pretty much parallel to what they're proposing with this accessory structure, correct?
Is a little bit the detached garage would be a little bit closer to the right of way than the house.
What's the reason for having a difference?
In the setback?
Yes.
I'm not sure. I know that when they were working on the ordinances, they didn't want accessory structures out in the front yard, lined up along the road. They wanted it to be accessory to the principal structure. That's my only understanding on that.
Okay, so it's more for aesthetics rather than issues with safety?
I believe so.
And what's your position regarding their request?
We have no concerns with it. The right-of-way is rather wide, so as Jennifer mentioned, there is quite a bit of distance still from the actual pavement of the road to where the start of the building would be, and I don't believe that it causes any sightline issues.
And you've heard them make a statement that they misunderstood the rules, and do you accept that statement?
Yeah, I think it's an understandable miscommunication.
We do have to address the standards. You did kind of cover those. I don't mean to exclude you. You are certainly entitled.
No, it's fine.
Please add whatever you wish to add.
No.
he's so used to this. I'm sorry.
This was his idea.
Yeah.
All right, so if you pay careful attention, we'll get through these standards fairly easily.
Okay,
Isn't it true That's the first clue. Isn't it true that the particular surrounding shape or topographical condition of the specific property involved would result in a particular hardship upon you, the owner, as distinguished from a mere inconvenience if the strict letter of the regulations were carried out? Isn't that true?
Yes.
You did well.
Thank you.
Because if you had to follow this 50-foot setback, you would have to pour more concrete and extend the foundation. Is that correct?
Correct.
And concrete at this point is fairly expensive, is it not?
Correct. And their biggest issue, truthfully, was the integrity of the structure if we had to do any modifications to it.
Isn't it also true that the conditions upon which the application for a variation are unique to the property for which the variation is sought and are not generally applicable to other property within the same zoning district? Isn't that true?
Yes.
And isn't it also true that the purpose of the variation is not based exclusively upon a desire to increase the monetary gain realized from the property? Isn't that true?
Yes.
You simply want to hide your husband's toys,
I
is that correct?
simply want to be able to pull my car into the garage.
Is it also true that the alleged difficulty or hardship is caused by the ordinance and has not been created by any person presently having an interest in the property? Isn't that true?
Yes.
Isn't it also true that the granting of the variation will not be detrimental to the public welfare or injurious to other property or improvements in the neighborhood in which the property is located? Isn't that true?
Yes.
And you're really not going to do anything to impede the flow of traffic on the road that's
No.
outside your house, correct?
Correct.
And isn't it also true that the proposed variation will not impair an adequate supply of light and air to adjacent property or substantially increase the congestion in the public streets or increase the danger of fire or endanger the public safety or substantially diminish or impair property values within the adjacent neighborhood? Isn't that true?
Yes.
By keeping your vehicles and your other things that you own indoors, that actually improves the neighborhood, does it not?
Yes.
And this is not going to be in any way an impediment to any light or airflow to your neighbors.
No.
And you're not close to any other buildings, so there's really no danger of fire, correct?
Correct.
And isn't it also true that the granting of the variation request, it will not confer on you, the applicant, any special privilege that is denied by this ordinance to other land or structure within the same zoning district? Isn't that true?
Yes.
If your neighbors were to make a similar request or to have a similar situation, would you think that their request should be granted?
Yes.
Is there anything else that you wish to say?
No.
I have nothing further?
Okay. This is a pretty straightforward request. It appears to be more of a technical issue rather than a safety issue. If this were the corner of the house, you'd be in compliance with our ordinance. I'm not quite sure why you have to be 50 feet off, but I think you've met all the requisite standards that would be in favor of your request, which means that this would go to the county board.
That would be February 20th.
Okay.
Okay.
Thank you. Do we attend that?
You don't have to.
don't have
Okay.
to.
They would just let us know what the decision was for that?
Yeah, when the police show up, they'll know. You'll be on what's called the consent agenda, and unless one of the members of the county board were to pull it off and to have a specific vote, you would be voted on that consent agenda, and all likelihood it would be approved.
Okay.
You would find out later.
Okay.
Okay? Good luck to you.
Thank you.
Thank you.
We all get to go home now because of the weather, or?
I don't know, we're gonna try.